So I want to welcome everyone to another Colorado Protectors podcast. This is the podcast of the Colorado Fraternal Police. My name is Frank Gale. I'll be the host for today's episode, which is about collective bargaining rights for law enforcement officers. We're going to be talking specifically about Colorado for the most part. We may talk in general terms about officers around the country, but this is really about officers in Colorado and how bargaining rights work for them. Joining us today is Sean McCauley, who is the General Counsel for the Colorado FOP Labor Council. Thank you for joining us today. Sean, can you just give us a little information about your background and your history and your experience?
Sure. Thanks for having me today, Frank. My name's Sean McCauley. I'm the General Counsel for the Colorado Labor Council. I'm a classically trained dying breed labor lawyer. I have been doing labor law for the past 24 years. My experience generally is representing labor organizations in the private sector, like the Painters District Council and the drywall finishers, to law enforcement officers in the public sector. I've represented firefighter locals at times, but primarily I've spent the majority of my career representing law enforcement officers, not only in collective bargaining, but also in a wide variety of other venues regarding discipline, and also in criminal cases where they've been charged for actions that they've taken in the line of duty. But the primary focus of my practice now, as I've gotten more into my career, is doing the negotiation of collective bargaining agreements, not only here in Colorado, but in Kansas, Missouri, and in Oklahoma. And that's primarily now what we are engaged in. And here in Colorado, it's grown significantly over the last several years, but I've been working in Colorado since around 2004.
So you're practicing actually in 4 states then?
I am.
And specifically with regard to labor representation of law enforcement officers in those 4 states?
That's correct.
And I know you said that you do some representation related to disciplinary matters or criminal cases that involve law enforcement officers that are accused or the defendant, but you don't. Do you do any of that kind of work in Colorado?
I do not.
Okay,
I do not.
So in Colorado, you only do labor law.
That's correct.
Okay.
Yeah.
So why don't we start out with you just tell us what is a collective bargaining agreement?
So I guess we have to really start where collective bargaining began, which was in the railroad industry under the Railway Labor Act. And that kind of developed back in the 1930s as a result of the exploitation of not only American workers, but some workers that were immigrants that came into the United States to find work. And most of them found work in industries like the railroads as they moved west across the United States. And there was a significant amount of turmoil and violence involved in the way the workers were treated. So gradually, this issue became of such importance that the United States Congress began to debate the idea of adopting a national law both to cover railway workers and potentially to cover other workers in the United States, specifically private sector workers. And through those debates came the Railway Labor Act, which gave bargaining rights to certain railroad workers. And then from there, and after World War II, with the number of GIs returning from Europe and the Japanese theater, and looking for work, the labor became a very preeminent issue in the United States. So Congress took upon itself to start looking at a way to allow for these folks to have some say in their workplace, to engage their employers to discuss rights that they would have, not only about how they were paid, but how they were treated. And before this, there really were no rights that we all now enjoy today. Many of those rights that individual workers, even that are not collective bargaining, benefit from, derived from the bargaining process. The idea of overtime, the idea of the Fair Labor Standards Act, the Family Medical Leave Act, eventually in the 90s. All of that kind of derived from the idea of collective bargaining. And when Congress decided to go the direction of allowing this, and this was not something necessarily new, this is something that existed in Europe long before it was adopted in the United States, and across the world in many other of the European states, they've looked to a way where workers can't really fairly negotiate, if you will, with their employer on an individual basis. You're essentially outgunned, outmanned, if you will, in that process, because it's you against the company, and you against the company, as anyone could figure out in most situations, especially in large corporations, is not going to fare well for the you. So they came up with a system by which the workers would come together as a group and negotiate as a group with the employer, giving them the strength in numbers essentially to even the playing field. And so the Congress adopted the National Labor Relations Act, which is the one that the majority of private sector and the construction industry and all the way to Starbucks, as we know now from recent events, they have an opportunity to bargain with their employer. And every private sector employee in the United States that's not a supervisor or excluded from the law theoretically has a right to bargain. And that even includes the 2 lawyers that work for me. And so if they would decide they wanted to do that, there would be a process for them to do that. However, when they adopted the National Labor Relations Act, they did not include public sector employees. Police officers, firefighters, municipal workers, street department folks, all of them were excluded from that law. For a variety of reasons, both constitutional, there was a concern about mandating that to the states when they were public employees, and that should be left to the states. But as collective bargaining grew under the National Labor Relations Act, and that's the Teamsters and all the stories of Jimmy Hoffa, all of that is under the National Labor Relations Act. The other states, especially on the East Coast, began to adopt public sector bargaining laws. And that gave the rights of officers and firefighters, as well as those street department workers, to bargain with their employer as well, because they had not had that opportunity. And each state adopted a law. In Colorado, it took a while for that to essentially progress west. And now we've seen a strong advent of collective bargaining rights in Colorado, especially in the last 20 years. So the bargaining agreement essentially is that group of employees that would be determined based on the fact that they all have some common interest, working together as a group to bargain over and agree upon eventually their wages and benefits that they would receive at the workplace, as well as their rights in certain circumstances. And those are eventually put pen to paper and signed as an agreement that's enforceable. Without a collective bargaining agreement, and most folks don't really know this, but from a legal standpoint, you may have some things that you are provided by policy or by the gratuitous actions of your employer, but those are not enforceable. And without a written agreement that's signed and enforceable, if those type of benefits were taken away from someone, there'd be little, if anything, they could do. So, for instance, if your employer had always provided sick leave to you and that was under a policy, there's no law necessarily that they're required to provide you paid sick leave. If they decided the next day that they could no longer afford that, or decide they just didn't want to give it to you anymore, they could take that away, and there would be little, if anything, you could do from a legal standpoint to essentially force them to continue that benefit of sick leave. And that's the real the real strength in the collective bargaining process, and the collective bargaining agreement is you are, as an employee, know exactly what your benefits are, and the rug is not going to be pulled out from under you one day because of a change in leadership within the company, or in our case, the public employer, because a new mayor comes in. We have a set of ground rules that are going to exist, and we can have a comfort knowing that they will continue.
So, so the benefit would be actually to having collective bargaining versus not having it is that you would have a document that lists what your wages and your benefits and other working condition items and so forth. That would be a contract that is enforceable through the courts if necessary.
If necessary, yes.
Yeah, okay. And so if you don't have that, management could decide at any time to change benefits, change wages. They could unilaterally make those decisions, and regardless of how that would affect the officers working in a given agency, the management of the city or the county could make those decisions, and there's really little or nothing that could be done about that.
That's correct.
Okay.
Yeah.
So that would be really kind of what the benefit versus not, benefit versus not having it. If there's not a collective bargaining agreement then in place, and most, the officers in Colorado don't have a collective bargaining agreement, how are they able to enforce their rights then regarding pay and benefits and things like personnel matters?
Well, it can become challenging. There are certain laws that outline certain types of benefits that you receive at work that they could not take away unilaterally, but they can be altered, especially in the public sector and especially in law enforcement. For instance, if folks are paid, everyone is entitled to overtime based on working in a threshold number of hours under the law. They could not, as an employer, take that away from you essentially and say, we're never going to pay you overtime. However, there's a significant amount of leeway within the law, especially under the Fair Labor Standards Act for law enforcement, where they could place you on a 28-day cycle with the threshold hours of 173 hours before you would obtain overtime. And if you took any leave time during that time, it would not count as hours worked towards that 173. So if you took a 2-week vacation, and even if you worked 60 hours of overtime in that 28-day cycle, your vacation would essentially nullify the overtime you worked. So there's ways to enforce certain aspects of what you have in employment. There's the minimum wage law. There's a law in Colorado that talks about wage pay, but there's a significant amount of exceptions, and it gives them still a significant amount of leeway to change those. So if you were making $35 an hour and they decided, well, we don't think we can afford that anymore, and we're changing it down to $27 an hour, there's very little you could do about that from an enforcement perspective. And they can make those changes unilaterally. They don't need your permission. But under the collective bargaining process, they have an obligation to bargain in good faith with the recognized organization. And in most circumstances for us, that's the Fraternal Order of Police. And if they intend to change something that is either in the contract or even a working condition that may not be in the contract, they have an obligation to discuss that with us before they make that change. We have multiple ways of trying to enforce that, but that's what the collective bargaining process really does, is it gives you a right to have a say in the outcome before the outcome happens.
So let me make sure we're clear about the overtime example that you gave. A lot of officers, they're working a 40-hour week, and they're getting overtime for anything in excess of 40 hours, and they don't have a contract in place. They don't have a collective bargaining agreement in place, but agencies are paying them overtime for anything in excess of 40 hours. But in fact, under the law, under federal law, Fair Labor Standards Act, there's an exception for law enforcement and public safety employees. It doesn't require employers to do that. And so employers could, who don't have a collective bargaining agreement, that are currently paying overtime for anything in excess of 40 hours, could actually decide, we're not going to do that, and we're going to wait until you've worked more than 173 hours in 28 days before we determine if we're going to pay you overtime. And then if you took leave time, then that would nullify some or all of your overtime. Is that accurate?
Right. That's right. And that's the Fair Labor Standards Act. And there's very minimal things that the employer would have to do to what's called avail themselves of the 7K exception for law enforcement. If you work at Walmart cannot avail themselves of that exception. The exception only applies to firefighters and police officers. So if the employer was paying you on a 40-hour work week or even an 80-hour work week, depending on the way your shifts work, there's some employers that do that. They could change that with a stroke of a pen and say, we're going to a higher threshold number of hours you have to work. And like in my example, 173 is the maximum before we're going to pay you overtime. And obviously, that's going to have a significant impact on the individual employee, especially if the employee takes any leave. And they can also, during that exact period of time, change your schedule. They can say you worked an additional 10 hours last week, and yes, those were overtime, and yes, that was an enormous burden for you to have to do during your regular 40-hour work week. But we're gonna flex your schedule. That's the common term, or alter your schedule to say we're going to give you another 10 hours off during the week, and we might do that 2 hours a day over the course of 4 or 5 days. And that is another way for them to nullify the overtime that you accrued, and that's completely legal. Now, under a collective bargaining agreement, they would have to agree about how we're doing that. And that's that's the opportunity that I'm talking about that you have through the collective bargaining process. That if you don't avail yourself of that, you're denying your opportunity to do so.
So having a collective bargaining agreement in place actually would provide you with more rights than the federal law provides you with, and the federal law couldn't interfere with that. Is that accurate?
That's correct. The federal law allows for parties to agree to something better than what is provided under federal law. And so the federal law is essentially the bottom rung of the ladder of what is possible in terms of that benefit. And so in many collective bargaining agreements, and I would say the vast majority, the overtime provisions within those collective bargaining agreements are substantially better than the overtime law that's provided under the Fair Labor Standards Act. Fair Labor Standards Act was designed to be the basement, the absolute minimum, just like the minimum wage, which is provided under that act as well, to make sure that it wasn't just rampant abuse. But that exception that applies to law enforcement and public safety generally definitely gives the employer a significant amount of discretion to make decisions about how you're being paid if they are not bound by a collective bargaining agreement.
Okay, that's good explanation and understanding of why it would be better to have collective bargaining in relation to that specific item or issue. What is it? How does it officers in Colorado go about getting collective bargaining? Is it easy, or is it reasonably difficult?
Well, the answer to that question has changed significantly in the last about 2 years. Prior to 2023, it was pretty difficult to get collective bargaining rights if you didn't have one. In Colorado, we did not have a statewide bargaining law. Many states like Iowa, Illinois, New York, Massachusetts, they have a statewide bargaining law that covers all public employees. And they've been bargaining in those states for the better part of 40 years. Even Kansas has a statewide collective bargaining law. Kansas has a slight nuance to its law in that the employers, the individual cities and counties, have to opt in to the law and coverage under the law. So it did not mandate to those folks in those different cities that they are required to bargain with their employees if their employees choose to do so. But in Colorado, we had no statewide bargaining law. So initially, much of the collective bargaining that was done in Colorado for police officers was done through individual city, or in some situations, home rule county cities, bargaining laws adopted in many times under an amendment to the city or county charter. So as an example, in the city and county of Denver, they amended the charter to allow for collective bargaining for law enforcement, both the sheriff's deputies in Denver, as well as the police officers and the firefighters. And just recently, the voters passed an amendment that allows the career service employees, certainly certain situated ones at least, to bargain as well. And that will be probably starting in, I think, 2025. But with that was a lot of work. In those places where we had collective bargaining under a charter amendment, it requires a vote of the people. So without boring you with all the ins and outs of that process, it's very difficult. There's only two ways that you can get that to the voters, and the first way would be for the city council to refer that out. And in many places throughout Colorado, the city council might be averse to the idea of collective bargaining. So they're not going to unilaterally or on their own do that. So as an example, the city of Longmont opposed collective bargaining, and the Fraternal Order Police, along with the firefighters, decided to go a route different than having the city council referred out, which is the gathering of signatures. And under Colorado law, if you obtain a certain number of signatures based on the election that you are going to run the initiative under, you can send it out to the voters to make a decision as to whether you will have collective bargaining rights by amending the charter of the city. And that is expensive, time-consuming, and very difficult from a political standpoint because these are just police officers and firefighters. These aren't professional politicians trying to run a professional campaign that, as everyone knows, in the United States, running any type of campaign is extraordinarily expensive. So that route was extraordinarily difficult, especially when the city itself was averse to the idea of collective bargaining. The one thing I would mention is that these bargaining laws came about by amendments to the city and the city charters, or the city and county charters. The reason for that was initially there was a question about the impasse procedure within these bargaining processes. And I didn't really talk that much about that, but under the National Labor Relations Act that covers all those private sector employees, that one that was adopted in the 1940s, if the parties aren't able to reach an agreement, the union or the individual employees can go on strike. Which means they can walk off the job and they enjoy certain protections as long as things have been done correctly when they went on strike, and they can't be fired for going on strike. And they use that concerted job action to force the employer to be reasonable in the negotiations and attempt to arrive at an agreement. Otherwise, under that law, there really is no other mechanism to force the employer to reach an agreement. And that was adopted based on experience throughout the United States at the time in the 1940s, which concerted activity was something that was seen as a strength for the workers themselves. In many of these charter amendments, they have a different type of impasse procedure because, especially with firefighters and law enforcement officers, going on strike would be dangerous. So they came up with an alternative means to try to settle those disputes, and they're called impasse procedures. And under these impasse procedures, they go to an arbitration process. And that was also arbitration. The idea of arbitration in the United States came about began with labor and the steelworkers, what's called the Steelworkers Trilogy of cases that went before the United States Supreme Court, where they found that arbitration was a meaningful and legal way to settle disputes without going to court. Traditionally, when you have a problem legally in the United States, you head to your nearest courthouse, whether that's your federal or your state courthouse. But arbitration provided an alternative means that was designed to be cheaper and faster and just as effective. And that would involve, instead of a jury of your peers potentially hearing your case, whether it's a civil case about a contract that you had with someone to cut your lawn and they didn't cut the lawn, or they did a bad job and you sued them, you would get a jury trial in many of those circumstances. You're waiving that and you're moving to an arbitrator who is either a lawyer or some other learned person that is experienced in that aspect of the law. And instead of going to a jury, you're going to that one individual, and he or she is going to make that decision. It's going to be binding upon the parties. It's faster, it's much cheaper, and you don't even have to have a lawyer if you want to go through the arbitration process, though I think in most cases you would prefer to have one. But anyway, the impasse procedures that are provided for in those charter amendments allowed for this arbitration process. And they wanted it to be binding so that when the parties couldn't reach an agreement during the negotiation process, they would have somewhere to go. It would be fast, it would be efficient, and there would be some finality in the decision. But the cities felt that that wasn't constitutionally permitted because it was an improper delegation of authority if that delegation did not happen through a charter amendment, meaning that the people of the city didn't give permission through a change to the charter to allow this arbitrator to stand in the shoes of the city council and make a final decision as to the wages of their employees. And so it has to be a charter amendment if you're going to have a binding arbitration process. But in the last probably 10 years, many cities in Colorado have adopted a ordinance process that provides many of the same rights and all of the same negotiation rights that you would normally have under a charter amendment, except the arbitration decision that I've been talking about, if we can't reach an agreement, is no longer binding on the parties, but rather advisory. It's not as good as binding, I think, from my perspective, but it's still a very good process that gives you a meaningful way to settle the dispute. And we've had very good success in those situations as well. So it doesn't necessarily have to be a charter amendment. It can be a ordinance that can be adopted by a city council on their own without the vote of the people, and creating this process. But all of those are challenging from a political perspective because there's a significant amount of engagement that has to occur before we get to a point that we're able to bargain. You walk into the private sector of the United States as an employee, and you automatically have those rights. You don't have to do anything to get them. And they exist for you. And if other members of your workforce want to engage in that process, you have the ability to do so. Public sector workers in Colorado don't necessarily have that right as they walk in. But like I said, that changed significantly in 2023 when the county collective bargaining law was passed by the Colorado legislature, and that gave all county employees of counties larger than counties with a population of 7,500 people the opportunity to bargain, and that included sheriff's deputies. And in that situation, right now in Colorado, every deputy sheriff that is working in a sheriff's department in Colorado in a county that is larger than 7,500 people has a right to bargain up to a certain level of rank within the organization. But that did not exist before then, and that was a humongous change for the better for especially law enforcement officers, deputy sheriffs specifically in Colorado.
So what I'm hearing you say is there's a law that allows county employees and then therefore deputy sheriffs who work in sheriff's departments who are, mostly members of the Fraternal Order of Police to go through a process to obtain bargaining rights, and they can do so under state law, and they have to meet certain criteria and take certain actions, and so they can gain bargaining rights, and that's been in place since July 2023. But for police officers and municipal law enforcement officers, they would have to do some kind of a local referendum. They have to do either get the city council to pass a local ordinance or refer out a charter amendment to the voters to amend the charter, or they could do an initiated referendum on their own under Colorado law that requires them to gather a requisite number of signatures to be for an initiated a ballot measure to be placed on the ballot and let the citizens vote. And so it seems that it's while it might not be impossible, it could be difficult depending on the jurisdiction you live in to get bargaining rights. But if you are a county employee, if you're a deputy sheriff, you actually have an easier path than municipal officers. But municipal officers may actually have an easier path depending on the relationship they have with the elected officials in their city and depending on the disposition of those elected officials. So it's not a simple answer, I suppose. I guess people who are interested in watching this podcast should probably contact Colorado FOP if they have more questions about how to get that done. And then, they can talk to you personally or they can talk to others about how that happens. Is there any difference? And I know that you represent both deputy sheriffs who have obtained bargaining rights and police officers who have obtained bargaining. Is there any difference in the way those people are represented in negotiations? Are the negotiations different? Is there some different dynamic? Is there some different process in the actual negotiations for the collective bargaining agreement?
Not really. I would say that the idea of collective bargaining, regardless of who's being represented, whether it's even public sector or private sector employees, is generally the same. It's a process that you would expect is at times adversarial, but works towards cooperative. And, it's really an opportunity for many of the same issues that affect individual employees in the workplace to be discussed and eventually agreed upon as to how we're going to handle those type of situations. So I would say there's really no significant difference between the two.
So if officers in Colorado were interested in pursuing the right to collectively bargain, what would be some of the common things that they could be expecting to negotiate over and put into the contract?
Well, obviously the big ones are, your wages, your retirement, potentially, depending on the location. Under the collective bargaining law for the county employees, retirement is something that can be negotiated, especially the contribution made by the employer. Your health insurance and other insurance that the employer might provide. Those are the big ones. Holidays, the number of holidays you receive, how you're paid on holidays if you have to work, vacation, how much time you would accrue, how you would get to use that vacation, whether or not that vacation could be cashed out if you were unable to use it, how much vacation can you carry over from year to year to provide yourself somewhat of a time safety net in case something came up that was unexpected. Sick time, both the accrual of sick time, the use of sick time, how you might become an abuser of sick time if they were going to determine that, and the criteria that would be used in that circumstance, and also if sick time would be paid out and your other time would be paid out at the end of your career. But there's other things, bereavement leave, smaller leaves that sometimes are provided for by policy, sometimes they're not provided for at all. In law enforcement, your rights when you are under investigation because of either internal or an external complaint, the manner by which that was investigated, the rights that you would have, whether you'd have a right to have an attorney present when you were questioned, if you were provided information about the nature of the investigation prior to being questioned, and other rights that you would receive during that process. a right to have a speedy determination made. And when I say speedy, I mean after a full and complete investigation, that the issue isn't held above your head for a significant period of time. Your rights to have your dues deducted from your wages, and how that would be done. Certain rights that the organization itself would have, a right to have leave in order to do organizational business, a right to have leave to attend negotiations or meetings regarding issues that arise under a collective bargaining agreement, and that would be paid leave you'd be negotiating over. So a wide variety of items that are contained within there. And those are normally set either by the law, the statewide bargaining law, or the individual bargaining ordinance and or bargaining charter amendment. And those tend to vary from city to city. Some things may be bargainable, some not. But the most important thing that's in that agreement is a grievance procedure to deal with issues that come up under the collective bargaining agreement, so that if I was supposed to be paid overtime in a certain circumstance, and overtime is definitely covered as a provision, and compensatory time, and whether you're provided compensatory time in lieu of overtime and how much time you can accrue. If they violated the overtime section and didn't pay you properly, you would normally have to go to court. And that's where I've talked about the arbitration process provides an alternative means to adjudicate that. And in almost every collective bargaining agreement we have in Colorado, I think everyone, it is a binding arbitration process where if there's a dispute that's not able to be resolved amongst the parties, and the parties being the city, and in our situation, the Fraternal or police, we then go to an outside arbitrator who's not selected by the city, not selected by us, but agreed upon by the two parties. And that individual hears the case, issues a decision, and that decision is final and binding. There's no going to court. There's no 16 years of appeals. It goes to that arbitrator, and the decision is final. There are some ways to appeal an arbitrator's decision, but they're very, very limited in Colorado and mostly across the United States, where it would have to be procured by fraud that someone paid off the arbitrator. Mm-hmm. And that, in my experience, has never happened. So, but that process might take 6 months at maximum in terms of from the time the issue occurs till the time we get a decision. And if you went to court, you'd probably multiply that by 3. Yeah. So that's the most important thing, because like I talked about at the beginning, if you have policies and procedures in place at your employer and they're followed, if they fail to follow them, there's no grievance procedure that's meaningful like the grievance procedure you'd find in a collective bargaining agreement. And that enforceability is what is the real value of collective bargaining, mm-hmm. holding everyone to the rules and a way to do that. So what I'm hearing you say is that if there's a collective bargaining agreement in place that covers wages, leave time and overtime and, various things, and the officer who is covered under that collective bargaining agreement believes that there's been some violation of the agreement by management, they would be able to file a grievance to have that resolved. And the resolution by that arbitrator is binding. So if the officer says they neglected to pay me overtime or court time or something like that they were entitled to under the collective bargaining agreement, then they filed a grievance and went to a grievance arbitration hearing, and the arbitrator agreed that the officer was entitled to this overtime or the court time or some other benefit under the contract, the employer would then have to give it to him. There's no other recourse. The order and the decision from the arbitrator compels the employer to do it. Yes, and the arbitrator's decision carries the same weight as a judge's decision. Mm-hmm. So if a judge orders someone to do something and they fail to do it, there's consequences. Yeah. Those same consequences apply to an arbitrator's decision.
So. And I heard you talking about some of the things that could be negotiated, and some of them obviously were things that were related to money. like wages and leave time and those kind of things, but also with things like assignments, promotion, and discipline. Could that be something that was addressed through a collective bargaining agreement?
It can be. How those are addressed, I think, tends to vary from city to city and county to county. But if a selection process is conducted, what's going to be part of that selection process, whether it's for a special assignment like being a canine officer or for promotion to corporal, sergeant, or even captain in some circumstances, may be covered by the collective bargaining agreement. Discipline is a real interesting one. In Kansas and Missouri, I would say that every one of our collective bargaining agreements cover discipline, meaning that in the vast majority of those that we represent in the Missouri and Kansas area, especially on the western half of Missouri, they all have binding arbitration over discipline, meaning that same arbitrator that might decide that overtime issue is also going to decide whether or not there was just cause for your discipline. And that is not universally a concept that is applied in Colorado. And we've had a back and forth, if you will, with the counties about that because of the sheriff's authority under state law. I don't necessarily agree with the sheriff's position regarding the dynamic between the ability to negotiate over discipline that's provided under COBCA, the county collective bargaining law, and the sheriff's authority. But we're trying to maneuver our way through that process because that is an interesting issue. But generally, under that law, you're allowed to negotiate over discipline. And in the cases where we have now collective bargaining agreements, we do have provisions that discuss how discipline is rendered. It's also there's also provisions on how investigations will be handled. And if those investigations are not handled correctly, we have an ability to enforce those provisions of the agreement.
Well, I mean, I think there's a long history in Colorado of elected sheriffs saying, that they get to run their agencies the way they see fit. They get to make decisions around discipline. They get to make decisions around how the disciplinary processes work, and the whole situation of how they will impose discipline and process investigations and so forth. Up until 2006. The people who worked in sheriff's departments actually served at the pleasure of the sheriff, which meant that the sheriff could actually fire deputies without cause, without any reason. They could literally just say, "You serve at my pleasure, and so today I don't want you working here anymore. Goodbye," and that would be it. And there was really nothing that could be done about that because that was the law. And in 2006, the Fraternal Order Police worked with people in the legislature, and we abrogated the pleasure statute that required the sheriffs to then, create some kind of a policy and a process around how they were going to do discipline. But under the new county collective bargaining law, disciplinary processes are fair game for negotiation, and I can see why there'd be a conflict that sheriffs are still saying, well, this one law says I get to create those policies, and the county collective bargaining law says that you can negotiate over them, and I guess that'll be a legal question that we'll work through. Although I know what the current law says. It doesn't say that the sheriff gets to do it. It says that that they're required to have some policies, and I don't think that's in conflict with the county collective bargaining bill. It's just because you would still be having policies. It's just be ones that you negotiate. But I'm sure they disagree with me, and they're free to do that. I was in management in the sheriff's department. I was a division chief. I think I know what I'm talking about. But they're welcome to disagree. It's America. You're free to be wrong, and they often are. So. We've talked about a lot of different things. One of the things you talked about was the arbitrations and grievances. One of the other aspects of arbitrations. I think we've covered grievance and how that works. Is interest arbitrations, what is an interest arbitration and how does that work?
So an interest arbitration is that arbitration process that comes during following the impasse between the parties' inability to reach an agreement at the table on their own. And under COBCA, that's an advisory arbitration process, and under certain city and county charters or city charters, it's a binding process. So it again is normally an individual selected from a list of learned individual arbitrators that are mostly lawyers that have experience in labor relations and make these type of decisions. So if you are proceeding to interest arbitration, it's really a battle of whose proposal for an issue like wages, for instance, is the most reasonable based on the factors that are outlined in if we're going with the city and a city charter. The city charter provides what the arbitrator has to consider. And, generally what the arbitrator is considering is really a two-prong issue approach. And that is, one, do the deputies or the officers deserve the wage increase that they're proposing? So, for instance, if the FOP is proposing a 6% wage increase, how does that 6% wage increase place those individual officers that are going to receive the wage increase in the market with other people doing similar jobs that they're doing? And we do that by saying these types of departments are comparable based on size, geographic location, type of work that's being done, and the amount of job responsibilities they might have. And for the most part, a law enforcement officer is a law enforcement officer in the state of Colorado. Excuse me. But there can be some nuances based on the size of the city and the type of work they're doing. And certain departments tend to be slightly different than others. But it comes down to, are we comparable with that? So if you're sitting in Westminster and you're going to an interest arbitration, you're going to compare yourself to Boulder, and you're going to compare yourself to Thornton and Longmont and Loveland, and probably Denver and Aurora, because you're of similar size doing similar work. And you might also include Commerce City, and then you might not, or you might include Englewood, or you might not. But many times we agree on who is the comparables in the negotiation process. Then the second approach is, even if we deserve the wage increase, we deserve it, meaning that this comparable market shows we need to be able to stay competitive with those other agencies for new employees and keeping our current employees. Even if we can demonstrate that, we have to also demonstrate that the city can afford it. They have the funds available to pay for the wage increase that we're asking for. And if they can't afford it, even if we deserve it, we cannot prevail. So it's that two-prong approach that they're going to look at. And anytime that we're making decisions about how we negotiate, we use that two-prong approach. And quite frankly, so do the cities. That's how they make decisions. If we look at what everybody else has and we can afford it, what do we need to do to stay competitive? And right now in Colorado, the competition for law enforcement officers is fierce. The changes made under 217 unfortunately drove a number of other officers either to leave the profession altogether or to leave the state of Colorado for other states where they felt they were, for lack of a better term, more appreciated by the folks that were making the laws in those states and in this state. So that competition is fierce. And so cities are cognizant and counties are cognizant of what other departments are paying when they're making decisions about what to pay their employees. And that's why, by and large, you've seen a rapid increase in the compensation levels of law enforcement officers in the state of Colorado. And that all is relevant if you're going to go to an arbitration process in an interest arbitration example. So that's the difference. Just real quickly, in a grievance arbitration, the party that claims that they've been wrong, that they think there's a violation, that party would bear the burden of proof, and they have to prove that the language was violated or a practice applying the language was violated. And you bear that burden of proof. And then the arbitrator just essentially makes a decision as to whether the contract was violated or not. So it's the grievance arbitration process where you're applying contractual language is much more defined in terms of what is presented in that type of case. But a fact-finding interest arbitration is much more expansive. You're going to be providing all kinds of information to that arbitrator to make a decision as to whose proposal in that circumstance is the most reasonable and most applicable and appropriate under the factors that he or she has to consider.
And so no party is bearing a burden of proof. Everybody's bearing a burden of proof instead of just, the grievant per se or the moving party having to do it in an interest arbitration. Both sides have an equal burden of proof.
That's correct.
Okay.
Yep.
And interest arbitration is binding. Is that correct?
It can be, yes. In certain circumstances, it's binding. It's binding on under certain charter amendments. If it's an ordinance, it's normally advisory, and under COPGA, it's advisory, which means that the arbitrator would issue his or her decision, and then the parties would go back to negotiate based on what that arbitrator said. And some folks listening to this podcast will be like, well, that's not very worthwhile. If it doesn't bind anybody, what does it matter? Well, it does, because that arbitrator's decision, if it is in your favor, is going to be very beneficial to you long and short term, because it sends a clear message to the city council in the circumstance of a city that, yes, we are underpaying our law enforcement officers, and citizens will take note of that. And from a long-term perspective, we establish that these are the places we have to compete with, and if we do not keep up, we are going to fail in an arbitration process in the future, because arbitrators in 2024 would look to a potential arbitration that occurred in 2018 on the same issue. They're not going to act as if it didn't happen. They're not bound by it like a court might be bound by precedent, but they're certainly going to be significantly influenced by it. And ultimately, if cities go and just say, we'll just go to the fact finding, we don't care if we lose because it's advisory, they would be treading on very thin ice in that circumstance, because that normally does not work out very well for them.
And so when you use the term fact finding, that's generally the term that's used for an arbitration that would not be binding, but would still present a lot of credible information that citizens and even elected officials would find compelling from an arbitrator who's a neutral third party.
Yes,
they generally don't have a dog in the hunt.
Yep.
I wanted to bring something up that you mentioned earlier. You were talking about in the process of this interest arbitration, when you're trying to, both sides are arguing their position and their proposal for the pay package or the wage and benefit package for a collective bargaining agreement, that if the jurisdiction, whether it be a city or a county, didn't have the money to afford what the workers wanted, what the FOP in representing the officers in that department wanted, then the arbitrator would have to say no, they can't pay for it. And so ability to pay is probably the most important factor for an arbitrator to consider. Is that accurate?
That's accurate. Yes. So
employers in jurisdictions that are claiming that they don't want collective bargaining because it's too expensive and it could bankrupt the city and so forth. That would seem to me that if ability to pay is the most compelling thing that the arbitrator is going to consider, and that nothing can move forward if the arbitrator decides they can't afford, it means that they couldn't go broke doing bargaining.
Yes. If they're truly broke or they truly don't have the funds to meet the financial obligations of the proposal made by the union, the arbitrator will not direct them that they should be paying those wages. But there are many circumstances where counties and cities may claim to not have the money because they've decided to expend the money elsewhere.
Sure.
That we would be able to unearth that as well. But for the most part, before we ever get to an arbitration, we already know that they have the money, because if they don't, we're looking for other opportunities to find a resolution.
Okay. Unfair labor practice. In Colorado, how would and who would determine that there was an unfair labor practice? How would you assert such a claim, and who would determine it?
So when the county bargaining law was adopted, they also adopted a process for the adjudication of what are traditionally called unfair labor practices. And most bargaining laws, including the National Labor Relations Act, as all the way down to COPCA, outline what the union or the employee organization and the employer can and cannot do. And mostly that is interfere with each other in a way that's disruptive and detrimental to the opposing party. The union could not do things that were intentionally designed to try to harass the employer, file grievances, go on strike, those type of things where we're trying to undermine the operation of the employer. The union cannot do. The same applies to the employer. They can't do things to try to disrupt or eliminate the union. For instance, if the union had an executive board that was made up of current employees, they couldn't fire all of them because they're union executive board members. That would be an unfair labor practice. If we have such undue influence by an employer, we have an opportunity to file a complaint with the Colorado Department of Labor. The Department of Labor then has an extraordinary amount of authority to order the employer to participate in an investigation and then ultimately gather information, and some of that information is required to be provided by the employer. And after a review of all of the evidence, both presented by the union potentially and the employer in response, the Department of Labor makes a decision, and that decision is directed to the employer that they do certain things. Sometimes it's just stop. Other times it can be put this person back to work and provide them a remedy for the fact that you unjustifiably fired them. But prior to the adoption of that law, Colorado didn't have any type of unfair labor practice process. So it did give a significant amount of protection to individual workers who want to engage in this process. The employer can still do heinous things, but we now have a way to remedy those that don't involve filing a lawsuit. And the lawsuit still is out there as well, but this process would be much faster than a lawsuit and be, I think, initially more effective in stopping bad behavior.
Okay. And, recently we did have to file something like that in Douglas County. That was in the news. We're not going to go into it, but other than for me to say, I applaud the officers and the deputies who work in Douglas County and the ones that are in the leadership of the FOP there for stepping up and having the courage to bring that complaint forward. And I think we had a successful resolution of our complaint, although some others might disagree. But I think that showed that we do, in fact, advocate for our members and we fight for our members.
Yes.
So closing remarks, anything that you'd like to add as we close out this episode of the podcast?
Well, I think that, we've provided a significant amount of information. This is a complicated process. The folks that have done it for a long time, I would say, like yourself, Frank, have learned on a daily basis something new about how to do things, what to do. So you never stop learning.
Yes, absolutely.
But it is not a process that you should be intimidated by. And you should also not buy into the idea that it's going to be detrimental, because the reality is that having a say in the ultimate outcome of your career. And in law enforcement, it is 100% a career. This is not something you're going to do for a couple of years and then do something else. This is something most folks plan to do for the rest of their working lives. You should have a say in the outcome of that. And if you don't have a say in the outcome, you're never going to be in the same position as those that do.
Okay. Just want to give one more plug. Colorado Police Officers Foundation. Go to coloradopolicefoundation.org, look at the work they're doing, and make a donation. Thanks.